Housing discrimination against persons with disabilities. Congress enacted the Civil Rights Act of 1866, Fair Housing Act of 1968, the Fair Housing Amendments Act of 1988, and the Americans with Disabilities Act of 1990 to protect certain classes of individuals from discrimination. Of particular interest is the protection afforded disabled persons in connection with housing discrimination. Here we will discuss the unique features of this group, the hurdles it faces in finding adequate housing, and the legislation enacted to achieve equitable treatment. The Fair Housing Act. Title VIII of the Civil Rights Act of 1968, also known as the Fair Housing Act, prohibits discrimination in all housing transactions, including sale, rental, and financing, on the basis of race, color, national origin, and religion. The Fair Housing Act was amended in 1988 to include anti-discrimination protection related to familial status and disability. The FHAA prohibits discrimination in the sale and rental of real property to the disabled. According to Eisner, it repudiates the use of stereotypes and ignorance and mandates that persons with handicaps be considered as individuals. Generalized perceptions about disabilities and unfounded speculation about threats to safety are specifically rejected as grounds to justify exclusion. The FHAA sought to achieve two goals. It aimed to integrate disabled people into the mainstream and increase their enjoyment of their homes. The Act cited 7 basic design and construction provisions for buildings occupied after March 1991 as follows: an accessible building entrance on an accessible route, accessible common and public use areas, doors usable by a person in a wheelchair, accessible route into and through the dwelling unit, light switches, electrical outlets, thermostats, and other environmental controls in accessible locations, reinforced walls and bathrooms for later installation of grab bars, and usable kitchens and bathrooms. The Americans with Disabilities Act was signed into law in 1990 to prevent discrimination against people with physical and mental disabilities. The ADA has 3 main goals. Title II of the Act provides that the disabled cannot be excluded from public services and programs. Title III provides that the disabled cannot be discriminated from full and equal enjoyment of public accommodations and commercial facilities. And, if needed, changes to accommodate the disabled must be readily achievable, that is, easily and inexpensively completed. Lastly, the ADA provides that all buildings built 30 months after July 26, 1990 must be accessible and usable to those with disabilities unless demonstrated structurally impracticable. According to Kubiak, the disabled encounter various barriers to finding adequate housing. Discrimination prevents them from securing affordable housing that is otherwise available, as neighbors misguidedly resist the disabled moving into their area. Given that 1 in 5 Americans has a disability and 5% of adults are mentally ill, the affected population is significant. In addition to discrimination, there are financial barriers to the disabled finding adequate housing. They are 4 times more likely to fall below the poverty line. Kubiak further notes that the most affordable housing is the housing that is least accessible to the disabled. Reasonable accommodations are still a hurdle because so many of the disabled are on a fixed income and cannot afford the costs to make adjustments. Lastly, cuts in federal funding for housing have resulted in a decrease in affordable public housing, as well as a decrease in investigations into housing discrimination. Classifying disability as a separate protected group underlines its unique nature. Whereas all persons have a race, sex, or national origin, not all people have a disability. All people are protected by the FHA against sex discrimination, but a person must have a disability in order to be protected from disability discrimination. Riley further notes that due to the unique nature of disability, not only does the legislation seek to protect the disabled against discrimination, it also implicitly protects against reverse discrimination claims. Although the FHA and FHAA are themselves silent on this issue, legal scholars have argued that the isolation of disability in separate provisions was meant to exclude non-disabled individuals from bringing reverse discrimination claims. Legislating separate provisions for disability allows housing providers to discriminate in favor of disabled individuals, meaning it allows housing providers to prefer people with disabilities over non-disabled individuals. This recognizes that some housing, including government-run programs, is designed and available exclusively for individuals with disabilities. Handicap is defined in 3 ways by the FHAA. 1, a physical or mental impairment that significantly restricts life activities. 2, a history of having an impairment. Or 3, being considered to have an impairment which excludes current drug and alcohol addiction. In the first category, major life activities include, but are not limited to, the abilities to see, hear, speak, walk, breathe, learn, care for oneself, and perform manual tasks. This provision encompasses chronic or episodic disorders that are substantially limiting when active or have a high likelihood of recurrence in substantially limiting forms. For purposes of the FHAA, alcoholics are considered handicapped regardless of whether they are participating in a treatment program or not. On the other hand, drug users are not considered handicapped unless they are participating in a treatment program at the time of the discrimination. The second and third categories are especially relevant for persons with mental disabilities by virtue of the behavioral manifestations of their illness. The FHAA makes it illegal to discriminate against the disabled as defined above, and the ADA requires reasonable accommodations be made to allow a disabled person equal opportunity for housing. Reasonable accommodations are key because they allow the disabled to make changes to their current housing when adequate housing cannot be found. They also allow maintenance of those changes, avoiding unnecessary costs when the disabled tenant leaves. For instance, if a doorway needs to be widened to accommodate wheelchair access and the tenant pays for the changes to be made, the tenant is not required to pay to revert the doorway to its original size after the tenant leaves. In the first few years after the FHA's passage, the Housing and Urban Development, or HUD, received an average of about 1,000 complaints a year. The passage of the FHAA in 1988 led to a surge in complaints, and by the mid-1990s reached 10,000 annually. The HUD, in coordination with 85 state and local agencies, has resolved nearly 94,154 cases since 1989, finding cause in 4,515 cases of proven discrimination. Compounding the problem is the difficulty in filing a claim. To bring a discrimination case, you must first file with the HUD within 1 year of the date of discrimination. The process is difficult, and many do not understand the forms or miss the deadline, while HUD does its best to dismiss the case at that level. The enactment of the Civil Rights Act, Fair Housing Act, and amendments, and Americans with Disabilities Act demonstrate that we have made significant strides in protecting disabled persons against housing discrimination. However, people's negative perceptions about the disabled, particularly persons with mental illness or history of substance abuse, the unique features of this class requiring individualization, the difficulty in filing claims, and cuts in federal funding all contribute to an enforcement that leaves much to be desired.